Michael Popok, Legal AF. We got a new middle-of-the-night ruling by Judge Kaplan against Donald Trump in advance of the E Jean Carroll second trial that starts in about a week, only on the measure of damage and the measure of punitive damages for Donald Trump's defamatory statements denying that he sexually assaulted E Jean Carroll, a Elle magazine editor, back in 1996. The only issue for this new jury is the amount of the damage that she suffered as a result of those particular defamatory statements against her made while Donald Trump was president. He has no immunity. The Second Circuit Court of Appeals has already ruled that. That trial is going forward. And now we've got this new ruling, which I'm going to read to you, in which it effectively says that Donald Trump will not be able to argue to the jury, this new jury, that he did not rape E Jean Carroll, mainly because the judge has found that he did digitally rape her, even though under the technical definition on some unique New York law, because the jury couldn't determine whether it was his finger, a digit, or his penis that committed the sex crime, they found instead that he had sexually assaulted her, jury number one, back in May of this past summer. And the judge is not going to allow Donald Trump to confuse the jury by arguing that he did not defame E Jean Carroll and didn't do it with the required element of actual malice because he only sexually assaulted her, maybe with his finger and not with his penis, and therefore what he said was substantially true. The judge isn't allowing any of that, thank God, to go before the jury. Let me read to you a memorandum decision that just came out, moments ago, by Judge Kaplan. And I'm going to read it almost in its entirety because it's that important to justice and to the findings that were already made. If people can't remember the E Jean Carroll result, E Jean Carroll was a successful editor for Elle magazine. She bumped into literally Donald Trump off the revolving door of a luxury department store in Manhattan that's still there, called Bergdorf Goodman's, right across the street from Trump Tower, or just down the block. And that led to an unfortunate incident in which she was the victim of a sexual assault. This has all been proven by a jury, a civil jury, back in the summer. 6-0 jurors in Manhattan found that it was more likely than not that Donald Trump sexually assaulted and possibly raped E Jean Carroll in a dressing room when nobody was looking, and then defamed her by denying that that incident happened and that he had victimized her. Here's what the judge has to say. Plaintiff E Jean Carroll moves to preclude defendant from offering any evidence, conducting any examination, or making any argument to the Carroll 2 jury that starts in a week that plaintiff failed to prove that defendant raped her within the technical meaning of the New York penal law, first-degree rape. She argues that the findings in Carroll 2 established that Mr. Trump raped her, as that term is commonly used, that the jury concluded as to penal law, rape in any case is not an issue preclusive against the plaintiff. It was unnecessary and immaterial to the jury verdict, and that the earlier jury's rape conclusion would waste time, confuse the issues, and not be relevant to determine the money damages that will be awarded to Ms. Carroll for Mr. Trump's defamatory June 21 and 22, 2019 statements while he was president, liability for which has already been established by the court on summary judgment. For all these reasons, the court has explained in great detail in prior opinions, the judge is going to side with E Jean Carroll. Here's what his findings are. 1, the jury in the earlier case found that Mr. Trump, now listen closely to this. This is a federal judge's recitation of conclusions and facts reached by a jury about Donald Trump. This isn't fake facts. This isn't opinion. This isn't conjecture. This is proven in a court of law off a couple of week trial with multiple witnesses and expert testimony and documents in front of a jury in federal court. And here's the judge's recitation of what happened. 1, the jury found that Mr. Trump forcibly and without consent digitally penetrated Miss Carroll's vagina. Even if there was doubt on that point, which there is not, the judge continued, the court exercised its authority and made the finding. So the judge is saying, even if the jury didn't make the finding that Donald Trump digitally raped E Jean Carroll, at least, the only issue is whether it was done with his finger, a digit, slash, and or his penis. The court made that finding as a matter of law. Accordingly, Ms. Carroll's statement that Mr. Trump raped her was substantially true under common modern parlance, regardless of the New York penal definition of rape. That's the first conclusion or finding by the court tonight. The second is that the earlier jury from the summer and their conclusion that Ms. Carroll did not establish first-degree rape within the meaning of New York penal law, and a little sidebar here, because the jury could not determine from the evidence whether he penetrated her with a penis, which is rape and the only type of rape recognized under New York law, or a finger or some other instrument. That's the only reason they didn't find rape, but they did find sexual abuse and sexual assault. The judge said it doesn't matter whether they found rape or sexual abuse because it's not preclusive against Ms. Carroll because it was not necessary to the outcome of the case to find defamation. In other words, there's no real distinction. It's a distinction without a difference between whether the jury found that she was sexually assaulted with a finger or an object by Donald Trump or with his penis. The third finding in the order, the only question for trial here, Judge Kaplan wrote, liability having been established on summary judgment by the court, concerned the damages that she's entitled to for the defamatory statements while Trump was president. Whether Mr. Trump, listen to this finding by the judge, whether Mr. Trump forcibly and without Ms. Carroll's consent penetrated her vagina with his fingers, as the Carroll 2 jury and the court both found, or also with his penis, has nothing to do with injury inflicted on her by his defamatory statements. The sting of the defamation was Mr. Trump's assertion that Ms. Carroll's charge of sexual abuse, call it rape, call it sexual abuse, it doesn't matter. For the purposes of defamation, it was entirely untruthfully fabricated and one made up for improper or nefarious purposes. Note also that Judge Kaplan does not refer to Trump as president or former president. Here, he is Mr. Trump at best. And here we have the final findings by the judge. And listen to this. I mean, talk about really nailing Donald Trump here in advance of his trial. This is a quote from the last page, second to last page of the order tonight. If the Carroll 2 penal law rape conclusion by the earlier jury and the judge from the summer were to have any relevance at all, it first would have to have been a determination that would collaterally prevent Ms. Carroll from contending that Mr. Trump forcibly and without her consent penetrated her vagina with his penis. And with his penis is italicized for emphasis. But as the court already has held, the penal law rape conclusion does not collaterally stop or prevent Ms. Carroll in any respect. But let's assume, the judge continued, for the sake of argument, that rape conclusion by the jury and that court, the court itself, were binding on Ms. Carroll and established that Mr. Trump did not forcibly and without her consent insert his penis into her vagina. The fact would remain, the court continues, that Carroll 2 and the court and the judge in the summer conclusively established that Mr. Trump did forcibly and without her consent penetrate her vagina with his fingers. He nevertheless falsely defamed her, the judge continues, from the most prominent bully pulpit in the world, right? The presidency, of having lied, of having made up the whole story. Thus, Mr. Trump's suggestion, Judge Kaplan continues, that the Carroll 2 penal law rape conclusion would be probative, right? Would be interesting to the jury to determine whether a fact in the case, the new case, were true or false, of whether his false and defamatory statements were made with common law malice, even if that rape conclusion were binding, which it is not, would be baseless. In any case, the introduction of the penal law conclusion from the earlier trial, the court continued, given that it's not binding on Ms. Carroll, would lead to a mini trial as to whether Trump penetrated her with his penis or his fingers, and thus a waste of time and confusion to the jury. So, the court rules that the plaintiff's motion for an order preventing or precluding Trump from offering any evidence or making any argument to this new jury that she failed to prove by a preponderance of evidence that she was raped within the technical definition of New York law versus sexual abuse is granted, meaning Trump will not be able to drag her through the mud and introduce to the jury to try to limit the amount of damages that she wasn't raped, she was just sexually abused. And the judge ends it with, defendant and his counsel shall not offer any evidence, conduct any examination, or make any argument relating to the Carroll 2's jury's determination from the summer that plaintiff had failed to prove that that defendant raped her within the meaning of the penal law. So ordered January 6, 2024, and in a very large, a very large Sharpie, similar to Donald Trump's, we have Lewis Kaplan, United States District Judge. Now, let me return to what this means. This means, and just to remind everybody, and we're going to follow it closely on the MeidasTouch Network and on Legal AF, that trial, which is what we call Carroll 2, there was already a trial over the summer that I've talked about at length here. A jury then determined that she was entitled to $5.5 million, including punitive damages, because not only did Donald Trump sexually assault her, but he also defamed her with malice and caused her economic damage and harm and intentional infliction of emotional distress. Draw a line under that case. New jury now about other statements Donald Trump made while he was president, for which he originally claimed that he had civil immunity, but that he lost that at multiple levels at the Second Circuit Court of Appeals, and they have refused to stay the case to allow him to take an appeal to the U.S. Supreme Court. And as of this hot take, Donald Trump has not and may not actually try to take an appeal to stop the trial, knowing it's a dead loser. So he's going to be in trial for E Jean Carroll too. I don't know yet who the lawyers are going to be. I can tell you who the losing side lawyers were for Donald Trump in May. It had been Alina Habba, the one that likes to be pretty not smart, based on her own statements recently. That pretty not smart Alina Habba had so screwed up the case leading into the trial that she got replaced by Joe Tacopina 90 days before the trial started. And when the trial started, she was nowhere to be found. Sure, she was in the courtroom, sort of as arm candy for Joe Tacopina sitting there, but she didn't do anything in the case. She didn't argue a motion, a hearing. She didn't talk to the jury. She didn't take a witness. Everything was done by Joe Tacopina, including a very ham-fisted cross-examination that backfired of E Jean Carroll by Joe Tacopina. Okay? Like a pugilistic boxer taking on a victim of sexual abuse in front of a jury in New York. That went terribly. And so Alina Habba made mistakes about DNA evidence in the case. She made mistakes about other experts in the case that got barred because she was late. She failed to properly assert presidential immunity at the beginning of the case. She forgot about it for 3 years, and it got waived by the Second Circuit Court of Appeals. That Alina Habba. I don't know who's going to try the case. I mean, the law firm of Keiss and Blanche and Lauro are sort of tied up right now with criminal trials that are about to start in March and May. So is it Joe Tacopina? We haven't seen him, hide nor hair of him, in a long, long time. Alina Habba did one thing in the civil fraud case. She cross-examined Michael Cohen. That's all she's done other than appear on Newsmax and other places. So I don't know who's the brain trust, and I use that term brain trust is doing a heavy lift here, that's going to actually defend Donald Trump. Maybe he shows up this time. Maybe he testifies. He swore he was going to last time. Instead, he ran off to Scotland and did a ribbon cutting at one of his golf courses because he's a coward, rather than testify. Maybe he shows up this time. But this new jury, the only issue for them is not retry the case, which Donald Trump wants to do. He thinks he's getting a do-over. Oh, I get to prove again that I didn't know her, I didn't touch her, I didn't assault her, I didn't rape her. No, you don't. That's not what this case is about. It's already been established conclusively that you did sexually assault E Jean Carroll, and that's the premise of the entire new order that just came out that I just went over. You only get to talk about what you did as president to defame her. And the jury is going to be instructed by the judge that he has already, prior to this jury being selected, decided as a matter of law that she has been defamed by those statements and that there is no immunity for them to consider. And the only thing for them to consider, this will be the judge's instructions on day one after they're selected, is for them to consider how large of a check to write in favor of E Jean Carroll for the defamation that she suffered, and how big of a check for punitive damages to punish Donald Trump, which also includes what his net worth is, because punitive damages is tied to net worth. And smartly, Robbie Kaplan, the lawyer for E Jean Carroll, is going to introduce statements made by Donald Trump touting and blowing and being a blowhard about his own net worth in the civil fraud case in the state court across the street, where he said, oh, Mar-a-Lago is worth $1 billion and 40 Wall Street is worth double what I paid and all. Great. Not only are you going to lose the civil fraud case because of your testimony, but all of your puffery about your cooked numbers are now going to be put in front of the jury here in the defamation case to set and calibrate the appropriate measure of punitive damages. Good work, Trump. And so that case, that's all that case is about in a box, not even liability, just damage. And we know what happened recently in a defamation case involving a Trumper who defamed women and women of color. That was a $150 million jury verdict against Rudy Giuliani. What do you think this jury is going to do with these instructions and with Donald Trump not being able to drag the victim through the mud, which he wants to do as a misogynist at core, in this current trial? A Manhattan jury, a second one, who may or may not know about the earlier trial from May, and being instructed this way by this particular judge. You think they're going to come in, at $5 million again? No way. Everyone knows about the $150 million verdict by the jury in D.C. against Rudy Giuliani. That just set a new market. That's a new high bar for defamation. If this jury doesn't come back in the $50 million to $60 million range, I'd be shocked against Donald Trump. And now you can just put your mind at ease about Donald Trump going after E Jean Carroll, whether he shows up or not, in front of a jury, because this Judge Kaplan is not going to allow it based on orders I just gave you the overview of. We do this kind of analysis only one place, at that intersection of law, politics, and justice, and we do it on the MeidasTouch Network and on Legal AF, the podcast we curate on Wednesdays and Saturdays at 8 p.m. Eastern Time on YouTube. Free subscribe to their YouTube channel, help them get to 2 million free subscribers, and then pick us up on audio podcast platforms of your choice. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.